So there are 13 grounds for divorce in Georgia. Really, there's 12 that are fault-based, and then there's one that's non-fault-based. The one you're probably most familiar with is irretrievably broken. In the movies, you hear irreconcilable differences. Basically, it's the no-fault ground for divorce in Georgia. It just means I want a divorce. And in Georgia, you don't actually have to have a reason for a divorce. You can just decide you want one and you get one. There are fault-based grounds for divorce in Georgia, such as habitual drunkenness, adultery, cruel treatment. If your spouse is convicted of a felony, that's one of the grounds for divorce. Duress, that's if you're pressured into getting married. If your spouse is a druggie, if your spouse has incurable mental illness, these are all fault-based grounds, but you don't need to have any reason. You can just say, I don't want to be married to this person anymore. And we file that almost 100% of the time, even when there are some fault-based reasons for the divorce, because it's just the cleaner, more vanilla way to do it, especially if you have children. You know, if your kids someday happen to look up the paperwork, it avoids mom or dad blaming the other party in a public forum in their divorce filing. So irreconcilable differences is what we file most of our divorces in Georgia on. So in Georgia, assets accumulated during a marriage are divided on the principle of equitable division. Now, equitable does not necessarily mean equal. It means fair. Most people think equitable means equal. And the truth of the matter is, most of the time, the starting line is down the middle, is 50-50. But then the court will look to see if there's any reason to deviate toward one party or the other. And of course, you and your attorney, if you're represented, which by the way, you should be, we'll get to that later, you'll probably want to get more than half. And of course, they'll probably want to get more than half. So in determining whether or not the division of assets should be 50-50, each getting half, some of the factors that can be considered are what were the contributions of each party to the marriage. Now, there's financial contributions and then there's non-financial contributions. Let me give you an example. You have one spouse who's working and the other spouse is home taking care of the children. So the spouse who's working obviously is making the financial contributions to the marriage and to the 401k accounts and to the investment accounts and that kind of thing. The one who's not working, they're also making a significant contribution, especially if they're staying at home, raising the children, looking after them, getting them here, there, and everywhere. And in particular, did they give up a career to be able to be a stay-at-home parent? So in calculating the division of assets, sometimes the party who was out making the money, bringing in the money, whose name most of the assets might be under, would think, well, I contributed more to the marriage. I should be getting more of the assets in the settlement. But that's not necessarily always the way that the court's going to look at it. The court wants to take a balanced approach, make sure that everyone is treated fairly, hence the term equitable division. So then there's the concept of alimony. So alimony, you'll also hear it called spousal support, is the idea that the spouse who has the lesser income, maybe even no income if they were a full-time stay-at-home spouse or stay-at-home parent, they're going to need some help getting back on their feet financially after the divorce. Now in Georgia, alimony is not meant to be a door prize, an exit prize, a walk-away reward for having survived marriage to the person, to your spouse. The purpose of alimony in Georgia is very specific. And pay attention to this. It is to help the party with the lesser financial ability to be able to transition into single life, life after the divorce. Let me give you a pretty extreme example. You've got a stay-at-home spouse. You've got a spouse who's working, making a lot of money, while the stay-at-home spouse has been financially relying upon the income coming in from the working spouse. And after a divorce, they're going to need some time and some financial help to be able to get themselves to where they can be self-supporting. So that's the purpose of alimony in Georgia. Now, there are a couple of different types of alimony in Georgia. One of them is the one you're probably most familiar with, which is payments, periodic payments on a regular recurring basis for a certain amount of time. And then there's the other type of alimony, which we call lump sum alimony, where at the time of the divorce, there is a specific amount of money that is allocated to be paid as alimony. And so you know a definite sum certain that you're going to be receiving. Now, sometimes that money gets paid out right away at the time of the divorce, or other times that specific sum of money might get paid out over a period of time. So there are two types of custody in Georgia. There is legal custody and there's physical custody, and I'll talk about both of them. So let's talk about legal custody. Legal custody deals with who is designated as the primary custodial parent, who's the non-primary custodial parent. And it also deals with things like final decision making. So if you have children and there's a custody case going on, there are several areas of decision making that need to have a tiebreaker. And so legal custody deals with who's going to be the tiebreaker in these various areas. For instance, healthcare decisions, education decisions, decisions on the religious upbringing of the children, decisions on the extracurricular activities of the children. Legal custody deals with who's going to have decision over those things. Now, sometimes one parent has final decision on all those things. Another time they're split up between the parents, maybe 2 and 2 or 3 and 1. And legal custody also deals with the rights to have information about the children's health as well as the children's educational progress. Primary custody is a determination of which parent has responsibility for the kids, for their physical, where they are most of the time. Now, obviously, as you guys know, a lot of times that ends up being mom, but not always, especially here in Georgia, where the rights of the father are being recognized more and more and more. And I actually see a lot of dads who get primary custody. But whoever has primary custody of the children has ultimate responsibility for their well-being, for knowing where they are. For instance, are they in school, are they home with the parent? And that parent has responsibility for the children. Typically in every divorce or every custody case, there's going to be a parenting plan. And the parenting plan actually lays out exactly where the children are at any given moment. For instance, a good parenting plan, you could look at that plan and know, given any given day of the year, you could look at that plan and know where are the kids right now. Are they with mom? Are they with dad? It lays out holidays. Are they with mom for those holidays? Are they with dad for the holidays? Are they in school? Are they in camp? Those are the kinds of things that go into physical custody and go into a parenting plan. Hey, if you have any questions about divorce or about custody, about the things I just spoke about in this video, go ahead and reach out to us. We're always happy to speak with you and give you a free case evaluation, help you figure out what you need.